Okay, today is March 7, 2011. This is Children in Justice. We're finishing up Learning Module 3. There's not a lot to do today. There's enough to get us through most of the class, but not a lot to do. We're going to focus on sex offender risk assessment, sex offender notification statutes, and sex offender civil commitment. Some of these things are in Professor Meyer's book, and some of them are in the readings that I gave you. But before we begin that, I want to take a look online and on the big screen at Learning Project 3, which is due next Sunday night. Learning Project 3 is a memorandum, and there's an upload link that I posted here. Thanks to Teddy for telling me that I didn't have it on there. But here's an upload link. And thanks to, I think it was Kirsten that told me the other one didn't have an upload link. But in any event, there's an upload link there, as well as an assignment and a fact pattern, a continuing fact pattern. Then there's two articles. Well, there's an article and a case. There's an article on the bottom on closed circuit TV called Facilitating Children's Testimony. You need to read that. And there's the New Jersey Supreme Court case, an edited version, State versus Crandall. And you have to read that case as well. Now, you will find out when you read that article and when you read the Crandall case that there is a procedure that is available for children in any court, really, but it is typically used in the criminal courts, but it can be used in any court, where the child may be permitted to testify on closed-circuit television. I mean, this goes back 20, 25 years. In the early days, when this law was passed, or this type of law was passed in other states, and eventually in New Jersey, it was a bit of a challenge for prosecutors and deputies, attorney general, and other advocates to set this thing up. There are a number of reasons why it was not embraced, not because it didn't make some degree of sense, but because it was difficult to execute the closed circuit technology. I think it's safe to say in 2011 that it would be a lot easier to do. You know, take yourself back in time to, well, let's see when Crandall, the New Jersey case, was decided. 1990. Well, take yourself back to 1992 and imagine putting a child in one room, the jury in another room, the defendant in another room, and having the child testify in one room and it be beamed to a monitor like we're looking at the front of this classroom in the courtroom. And then maybe have a third monitor somewhere else for the judge to look at, perhaps. Well, that's a lot of technology that was big, awkward, difficult to hook up, unreliable. When the waves went through all these wires, if something could go wrong, it typically did. But now, you know, the new iPad's coming out in a few days. I'm going to be trading this in. And if you all had iPads, we could never come here. We could all look at each other on the face-to-face or FaceTime. The point is, with Skype and iPads and the new technology, you can set up something with a couple of laptops, for Pete's sake, where a child can testify in one room and the signal can be broadcast to a 50-foot monitor in the courtroom, you know, for $100. There are other things about it, and we'll talk about that when we meet 2 weeks from today. You all have your reservations for South Padre Island? You know, it's spring break. Right? No? Lauderdale? Cabo? Brazil? Journal Square? lot happening there. There's some newsstands, right? We'll talk about other reasons why closed-circuit television might not be all it's cracked up to be. But I want you to read Crandall, and I want you to read the article from APRI on the bottom. Look at the fact pattern, and your role is as the caseworker, and you're going to write a memorandum or an inter-office memorandum or an internal memorandum from you to the Deputy Attorney General that's handling this case. This again is the Sam Ruth, Barbara Ruth, etc. You're going to write her a memorandum outlining why you think there should be a Crandall hearing and that the child ought to testify on closed-circuit television. And when you read the case and when you read the article, you will learn what the requirements are in order to get the court to permit a child to testify in another place and not have to face the defendant. Now, when you read the fact pattern, the assumption here is that the case is in the criminal courts. There's a parallel DIFUS action, child protection action. There's a DAG assigned to the case named Ann Silvestri. There's a prosecutor, Elizabeth Torres. We're all working as a multidisciplinary team, and you know the kid better than anybody, right? You know that little girl better than anybody. You know the case dynamics because you're working with the family. The prosecutor doesn't work with the family like you work with the family. And you know more than the average caseworker because you have a degree from Montclair State in child advocacy. And you understand the intersection of the civil system, the criminal system, and the family system. And you know that this child doesn't have to sit in the courtroom and look at the father who molested her and give evidence against him and go through that unforgiving process. That there's a better way, a more sensitive way perhaps. So what you need to do is advocate for that kid to your DAG and explain why this child should get a Crandall hearing and ultimately should testify outside the presence of the defendant. If you remember, the little girl's name is Wendy. You're going to advocate for Wendy. And similar to the last learning project, you have to pay attention, you have to be thorough. Thorough doesn't mean write 20 pages or 5 pages or lots of words. Thorough just means reading the fact pattern, reading the case. When you read the case, the court will tell you what has to be done. You can even make a little checklist. What are the factors that the court will consider in making a determination about whether the child can testify outside the presence of the defendant? And is it in my case? So if, for example, the court says the child must be less than 12 years of age, factor 1. The child must be taller than 3 feet tall. Well, read your fact pattern, see if the child's more than 12 years, see if the child's more than 3 feet tall. You want to not only outline what the Crandall process is, what the factors are, but also express them in your memorandum and explain why they apply in your case. Well, in this case, I spoke to Barbara Ruth, and Barbara Ruth told me that the last time her daughter went to the doctor, she was 3 feet 1 inch tall. So that was the second factor that the court outlined, and clearly the child meets that factor. Now, Wendy needs to be at least 12 years of age. When I last spoke to Barbara Ruth, she indicated that there was some uncertainty about her birthday because Wendy was adopted, and there was a mix-up with the paperwork when she was adopted. So we don't know the answer to that, but we need to find that out. I'm making all that up. That's not even part of the fact pattern about adoption. She's a biological child according to the fact pattern. But the point is, sometimes there's information that you don't have. The court may say, well, we need to know if they have, O-type blood. And if it's not in the fact pattern, you need to say that's what we need to know, and we need to do further investigation. And then we'll talk more about it when we meet again. Recognize when you read this stuff that there is a constitutional issue here. There is a constitutional issue involved in the Crandall case that doesn't have to go into your internal memorandum, because the DAG doesn't care about your observation that there's a constitutional issue involved in Crandall, but you need to know that because we're going to talk about that as well. Any questions about this learning project? Okay. What's that? Well, that's a good question. Let's take a look. Oh, it is. When we meet again in 2 weeks, you'll be taking the midterm. Good call. No, does that make sense? When? Oh, yeah, next week's spring break, right? Then there's no class next week. And then we come back on the 21st. Yeah, no, there's no review, but I'm looking here. Yes, you have to complete learning module 4. So you're going to begin that tonight, and you'll complete that. That's for this week. And you have to do, that's learning module 4, and you need to do this learning project. There will be a discussion board here where you can post questions right here for the midterm examination. So if you post here, your fellow students can help you out, and I am going to subscribe to this right now. So now that I've subscribed to this forum, every time you post, it'll get pushed to my email and my phone, so I'll know what you're asking. Okay?
So we're not going to have a chance to go over learning module 4 before the exam?
Well, you know what I'll probably do? I'll probably just focus on learning modules 1 through 3. Let me take another look at the course schedule. Yeah, what we'll do, the exam will just be on the first 3 learning modules, because I will not have had an opportunity to go over it with you in class. Okay? Does that make sense? So it'll be through today's lecture. The lectures are posted online if you want to review them again. If you want to post questions, they'll go right in that discussion board, and they'll come to my phone, and other people might answer, and I might answer too, okay, if there's something that's on your mind. And if you want, we'll have a little time today, if you think of something, after we do sex offender risk and notification. we can certainly talk about whatever you want to talk about. Speaking of speaking of review, can somebody tell me, you see up there on the screen, mandatory listening in Ray GAULT. What did the GAULT case mean? What was the GAULT case about? Why was that an important case in juvenile law and family law in the United States? Go ahead. It gave juveniles their due process under the 14th Amendment. What does due process mean? What kind of good things happen? What kind of protections do you get through the due process clause of the 14th Amendment? What are some of them? Well, juveniles now have a right to an attorney to defend them. That's true. The right to counsel. That's the Sixth Amendment of the Constitution, one part of it. And GAULT's guarantee of due process includes the right to counsel. What else? What other rights did GAULT guarantee for juveniles that before that were not? Well, they had right to an adjudication or to a hearing.
He wasn't able to contact the child. So he had like a protection order in a sense. He could contact the child.
You're talking about the attorney in the GAULT case.
Yeah.
Right, and out of that case came the right to cross-examine witnesses. Juveniles have the same right as adults have to cross-examine witnesses. They got a right to an attorney. What's a fundamental right that they didn't have in medieval England, they didn't have in Soviet Russia, they didn't have in, and don't have in some of these totalitarian regimes that are crumbling? What's that? Well, they didn't have that, and that is guaranteed by GAULT as well. So the privilege against self-incrimination and the right to remain silent is part of GAULT. But that wasn't what I was thinking about. I'm thinking about in these other places and time periods when they take you and arrest you. Alp?
Notification of charge?
Yeah, they wouldn't tell you what you were charged with. They just put you in jail. They put you in a star chamber in England, and you don't even know why you're arrested. Well, after in Ray GAULT, juveniles are entitled to notice. Notice to what the allegations are, right to counsel, right to cross-examine witnesses, right to remain silent.
Do they have the right to, like, a jury?
Well, that's a good question. No, they don't. And you don't need a jury to have due process. Juveniles don't have a right to a jury trial, primarily because the role of the family court is rehabilitative rather than punitive. They want to rehabilitate you rather than punish you. So the ultimate outcome isn't one that's punitive. But even though it's not punitive, even though you're not supposed to be punished and go to jail or be locked up or incarcerated for a significant period of time, even though that doesn't happen in the juvenile courts, you still have a right to due process. You still have a right to fairness, and certain rules apply. But you don't have a right to a jury trial. And that's one of the big differences between the juvenile courts and the criminal courts. No jury trial, no right to bail. So the case is decided by a judge, not a jury. There's no right to bail. You either are kept in custody for your own protection, or you go home with your parents. What about parents and GAULT? What did GAULT say about parents? What kind of fairness involving parents was a ruling in the GAULT case?
I have one
So that means he was charged without what? Without telling who? Parents. And GAULT changed that. So what's the rule now? You got to notify the parents. You got to make a reasonable effort to notify the parents. And as I said last week, unfortunately, in some cases, kids grow up in less than adequate families. You can't even find the parents. Or the parents won't come. Some parents are so frustrated, the police call, they just start cursing and barking and hang up. They won't even come. Well, in that case, the parents were notified if they yell at you on the phone and hang up. But if you can't find them in a reasonable time, you can still charge the child. So we looked at the juvenile courts last week. We also looked at child abuse reporting laws. We talked about any person states, like New Jersey, and mandated reporter states, like New York, where there's a list of people. We also learned that, if we didn't already know it, that mandated reporters don't always report. Even professionals don't always report, knowing they should report. And that there are a number of factors that influence that decision to report. Like, will it do more harm than good? Is there enough evidence? If I call it in, won't that screw up the kid's therapy? It's not that serious. All they're going to do is come into this child's life and make things worse. The less serious, the more likely someone won't report it. If the kid's older, that's another factor that influences the decision to report or not report. Well, even though people and professionals exercise discretion sometimes in reporting and not reporting, the law knows no such discretion. You must report. And if you do not, it's a disorderly person's offense, punishable by jail up to 6 months. That doesn't mean it gets prosecuted necessarily. Sometimes. But as I characterized it last week, there is some teeth in the law. By teeth, I mean there's a punishment. The other thing to encourage people to report is that even if you're wrong, it's okay. If you're mistaken, if you're honest, and you're wrong, you cannot be successfully sued. The only persons who could be successfully sued are those who report in bad faith, who report in order to manipulate people or to get people in trouble or to advance some agenda other than a true case of abuse or neglect. In that case, you could be sued. But there is a good faith exception. Which means you cannot be successfully sued for reporting. To the contrary, you can be punished for not reporting. That's a little review of some of what we did last week. Everything else is posted online, the entire lecture. Is there something you want to ask about that stuff? Okay, I have your risk assessments that you did, and I'll be looking at them over the next few days, hopefully. We're going to talk more about sex offender risk, sex offender registration, sex offender notification, and civil commitment, what are commonly known as Megan's laws. Excuse me. Now, I mentioned to you last week that New Jersey was not the first state to have sex offender registration. It was actually Washington State up in the Northwest, where there was a boy who was raped and brutalized and murdered, and they initiated a notification statute. New Jersey's was inspired by the murder of Megan Kanka over in Hamilton Township outside of Trenton in New Jersey. The idea was that if Megan had knew to stay away from that house, that there were bad people there, that she might not have been interested in whatever Jesse Temendequaz had to say, the guy who lured her over there. She might have been spared and be alive today. The assumption is that if you notify the community can take steps to protect itself. And if the sex offenders live in secret, then we are vulnerable to them. The other assumption that led to Megan's type laws is that sex offenders are recidivistic. That is, that sex offenders are repeat offenders. That they do these kinds of crimes over and over again. So that even though a person has served their time, they still pose a significant risk to the community. That's the assumption behind Megan's laws. That these kinds of offenses are high-risk, recidivistic offenses. And there's some validity to that with certain kinds of offenses and many offenses that really don't fit the pattern of recidivism. So when the statute was passed on October 31st, 1994, it compelled people who were convicted or adjudicated delinquent. Who am I talking about when I say adjudicated delinquent? Minors, children, juveniles. If you were convicted or adjudicated delinquent of a sex offense, after the law passed on Halloween 1994, you must register as a sex offender with the chief police officer in the town where you live, the chief of police or his designee. So if you commit a sex crime after October 31st, 94, you must register. If you were on probation or parole in 1994, specifically Halloween 1994, October 31st, you must register with the chief municipal police officer in your community where the sex offender lives. And there was one other class of sex offender that has to register without regard to when they were convicted. And those are people who were sent to the Adult Diagnostic and Treatment Center at Avenel, New Jersey. Now, within our prison system in New Jersey, there is a facility where they incarcerate certain sex offenders, and they're called repetitive and compulsive sex offenders. Every sex offender who gets sentenced in New Jersey has to get evaluated by a psychologist at the Adult Diagnostic and Treatment Center. It is in the shadow of Rawway Prison in Avenel, New Jersey. In Union, is that Union? No, that's Middlesex County. Middlesex County. It's a separate facility, but it's on the, and I use the word broadly, on the campus of Rawway Prison. You can see the medieval building off in the distance. It's decaying dome. They're right near one another. This section, though, houses the most obsessive sex offenders. The ones that cannot control their behavior. Thus, the characterization repetitive and compulsive. They're the kinds that repeat and can't stop repeating. If you ever went to Avenel, and we use that as the term to describe this facility, that's just the name of the town. The facility is called the Adult Diagnostic and Treatment Center. If you ever were sentenced to the Adult Diagnostic and Treatment Center, without regard to when it happened, you have to register. So to recap, if you went to Avenel, you have to register. If you were on probation or parole on October 31st, 1994, you have to register. And if you were convicted of a sex offense after that day, you have to register. Now, you could have been convicted of a sex offense in the 1980s. If you went to Avenel, you have to register. As my great colleague who's now passed away, Jack Wood, said when this law passed, the statute reaches back to antiquity. A long time ago. It doesn't matter when. If you went to Avenel, you got to register. In fact, before Avenel, there was a sex offender treatment facility in Menlo Park, New Jersey. Now there's been a mall there for 40 years, but there's a nice mall there now. So that's how you get on Megan's laws. You commit a sex offense, you're required to register. And you are required to register with the chief law enforcement officer in the town where you live. So that's generally the police chief. If you're in rural Sussex County or rural Cumberland County or Salem County, where they don't have any police chief, then you register with the state police. There are some sections of New Jersey that are patrolled exclusively by the state police. You register with them. A registration is simply a square card upon which the policeman or woman puts your fingerprints and some basic information about the sex offender. Name, height, weight, scars, tattoos, typical identifying characteristics. A photograph. They take a fresh, new photograph. All of your physical characteristics, like you're going to the doctor, height, weight, the whole nine. photograph, a short description of the sex crime you committed. They take that card and they forward it to the county prosecutor after making a photocopy. So now the sex offender is registered locally with the municipal police. Whether you live in Voorhees or Union or Cranford or Wyckoff or Patterson or Clifton or anywhere in New Jersey, the police departments in those municipalities will have a card on you. The police departments in every municipality know who all the sex offenders are in their municipality because they have to register. They take the card and they send it to the county prosecutor. So you're going from purely local registration to regional registration. The card goes to the county prosecutor, whether it be the Mercer County prosecutor or Bergen County prosecutor or Union County prosecutor or whomever. It goes to that prosecutor's office sex offender unit, and they have a county-wide database of sex offenders. So the prosecutor has a database with all the sex offenders in the county. Why? Because every police department sends them the card. They make a copy of it, and then they forward the original card to the state police. The state police maintain a statewide database. They have a database with every sex offender in the state. Most of the heavy lifting is done by the county prosecutor, though. What happens is, not only do you keep that card and that information, then you have to get all of the offense history and social history of that sex offender. All of the police reports, hospital reports, psychological reports, probation reports, everything you can gather about the history of this sex offender. Because the prosecutor is mandated to perform a risk assessment. And that's what you all did, that you submitted to me. A risk assessment. Because the Supreme Court of New Jersey does not allow us to notify the community every time a sex offender moves into town. We don't share everything about the sex offender with the entire citizenry of New Jersey. There is a case called Doe versus Poritz and E.B. versus Venero, which was a federal district court case that went to the Third Circuit Court of Appeals. Both of those cases said that Megan's laws are constitutional and administrative. They're not punitive. They don't punish people. They're administrative. Doe versus Poritz and E.B. versus Venero. However, they said that the prosecutor and law enforcement cannot distribute Megan's Law information to the public without conducting an independent risk assessment. And that notification has to be tailored to that particular sex offender. So if the sex offender is someone who rapes adult women, and you're allowed to go and notify, you don't notify daycare centers. But you do notify battered women's shelters. It has to be tailored tailored to that particular sex offender and his pathology, his way of thinking, his victim type, his modus operandi, his way of committing crimes. The statute sets up a graduated system of notification, which means goes from lower to higher. Everyone who's a sex offender who gets out of jail, everyone who's a sex offender that gets out of jail is a tier 1. If you commit an offense, and it's a sex offense, and you're convicted or adjudicated delinquent, tier 1. Tier 1 is the limited notification, and it involves telling the police in the neighborhood where the sex offender lives. So you tell the police in Little Falls, if the person lives in Little Falls. You tell the police in Caldwell if the person lives in Little Falls but works in Caldwell. You tell the police in Little Falls, Caldwell, and Long Branch if the sex offender lives in Little Falls, works in Caldwell, and has a summer home in Long Branch. Wherever the sex offender has a meaningful presence, you are permitted to share registration information. Excuse me. If the sex offender goes to Kenilworth 2 or 3 times a year because he's part of a club that meets there, that wouldn't be enough. You need to have a meaningful presence in the community. Certainly owning a shore house and working somewhere and living somewhere are meaningful presence, are meaningful examples of a meaningful presence in the community. So tier 1, you notify the police. And the prosecutor will prepare a flyer. And that flyer will be shared with the municipal police wherever the sex offender has a presence as I just described.
How often they're supposed to report to the police?
Thaddeus said, how often do they report to the police? And Carmen is correct, it's 1 year. And they are required to visit the police every year to confirm that they haven't moved and that they still live at the same address. If they do not appear at the police station on a yearly basis, they will be charged with a 4th-degree felony, failure to register. Excuse me. And we arrest many, many people for failure to register because they don't always verify their address. That's what that's called, address verification.
So, the reason I ask is, unless I didn't understand it, but in the project that we did, Wiley Jason, I think he did report like 90 days. In 90 days, and he was violated. Did that change from, in the risk assessment that we did in his history? I think part of the violation was they said he didn't report like in 90 days or something like that.
Thaddeus says that the subject of your learning project did not report in 90 days or so, and he was charged. there's an exception for the 1-year rule for failure to report. And it takes us back to the campus at Rawway Prison. If you ever went to Avenel as a repetitive compulsive sex offender, then you must verify your address every 90 days. That's probably what happened with him.
And he did good.
He did go to Avenel. There you go. Sex offenders who register with the municipal police have to verify their address every year, unless the sex offender was sentenced to the Adult Diagnostic and Treatment Center in Avenel, New Jersey. If you were found to be a repetitive compulsive sex offender and sentenced to the Adult Diagnostic and Treatment Center, you must verify your address every 90 days. What that means is, every 3 months, you go down to the police station and say, "Hey, how you doing, Officer Stradella? Remember me? I still live at 123 Market Street. Here's a PSE&G bill. Here's a picture of me standing in front of the house with a newspaper." You have to provide proof that you still live at that residence. Unless you went to Avenel, then you got to do it every 90 days. It's a yearly thing unless you went to Avenel. The next level of risk is Tier 2. Tier 2. Tier 2 notification goes to the police. Just like before, we'll use our hypothetical where a man lives in Little Falls, works in Caldwell, and has a shore house in Long Branch in Monmouth County. If the sex offender is a Tier 2, then you tell the police in Little Falls, Caldwell, and Long Branch, and you tell schools, all public schools, all private schools, any and all schools, all licensed daycare centers, group homes, and the like, and registered community organizations. So, to say it again, you tell the cops in the 3 towns, and then you also tell all the schools, all the daycare centers, they're automatic, and any organizations that applied for notification that deal with vulnerable populations. So if you're a karate school or a dance studio or a wolf pack that meets at the same place every month or twice a month, you have to fill out a form and convince the county prosecutor that you have a consistent presence at a single location and you have vulnerable persons at that location. Battered women's shelters, dance studios, karate schools, and others. Go ahead.
What about, like, does this depend on the age of the sex? I mean, the age that the sex offender or just because it's a Tier 2?
Well, that's a good question because, as I said earlier, the notification has to be tailored to the pathology or the way of thinking of that sex offender. So if it's an adult rapist, you're not going to tell daycare centers. We're entitled to tell them. They're among the class that gets notice, except for this guy, they won't get notice because there's no evidence that he poses a risk to preschoolers. There's not a correlation between sexual violence on adult women and the molestation of preschoolers. They're 2 different things. So, yes, the answer to your question is yes. Who his victims are, and the kind of offense that he committed, is relevant to the risk assessment. Now go ahead.
Do you notify recreational centers?
we could, if they apply, and if the rec center has children there at a single location regularly. And the reason why I stress those factors, single location regularly, is we get applications from local troops of Boy Scouts or Girl Scouts. And then I say, well, where do the kids meet? And they say, well, sometimes it's at Mrs. Stombash's house, sometimes it's at Mr. Del Russo's house, sometimes it's at Grandma Nelson's house. It all depends. Well, you're not going to get registered because you need to be in a certain place. The notification can't go to an institution. It goes to an institution that has a presence in the community. I'm not sure who to notify if it changes from month to month or week to week. So yes, a recreation center sounds like the perfect kind of place. Now, many rec centers are part of a school, not all of them, or a church that might be already registered. You know, I see a lot, St. Anne's Parish, and they have a rec center in the afternoon. Same parish, same school, but often they do apply as an independent rec center, even though it's part of the same parent institution. Go ahead.
But the information is available online as well, right?
Well, not everything, and not for every sex offender. We'll talk about internet publication in a moment. Go ahead.
When you say this, the schools and private schools, you're just in reference to those towns, right? Not
Say that more loudly.
the schools. It's just in reference to the towns that frequented, or is it statewide?
The schools in, go back to my hypothetical, Little Falls, Clawell, and Long Branch. Yeah. Those schools that are like, those places and organizations that are likely to encounter the sex offender. That's the magic words in the Doe case. Likely to encounter. I try to switch it up a little bit so it makes a little more sense. It's the area where, or the place where the registrant has, or the sex offender has a significant presence, meaningful presence. And the zone of notification is in the neighborhood where he lives. What does that mean? It means something different in every neighborhood. And that should be the way it is.
How do the notifications go out?
Say that more loudly.
How do the notifications go out?
We're going to get to that next. That's a good question. The question by Priscilla was, how do the notifications go out? Now, for the Tier 2 notifications, they're a flyer. They're just an 8.5 by 11 piece of paper. There's a photograph. There's a few paragraphs of language that tells people to leave the person alone, that they haven't committed a recent crime, that this notification is not designed to punish them, and if you harass them, you will be charged and prosecuted. At the bottom, it tells them the kind of car they drive, what color hair they have, what color eyes, how tall they are, how much they weigh, what their address is, and a little bit of information about the crime itself. That flyer is shared with the rec center, the school, the daycare center, the karate school, and they are trained and emphatically told that this is just shared with staff that are in a position to see unauthorized persons on the premises. So there's another definition you have to remember. Persons who are in a position to observe unauthorized persons on the premises. Let's use the school example. The principal gets the flyer I described earlier. It has the name, the picture, the type of crime, information about the sex offender. The principal gets it. They share it internally, not with everybody in the school. They don't post it in the lunchroom or in the teacher's lounge. they identify people that are in a position to regularly observe, or that are regularly in a position to observe unauthorized persons at the school. So to give you an example, you would share that with a school crossing guard, a gym teacher, hall monitors, school resource officers. You wouldn't share it with the principal's secretary, or the nurse's assistant, or even the nurse. You got to be the kind of person that gets out of your office and you're in the common areas of the school, because you're supposed to be looking at this person, and if you see him in the parking lot, or you see him in the playground area, or you see him in some common areas of the school, then you can call the authorities or investigate further. So the flyer is shared with the principal, or the president of the daycare center, or the chief officer of the rec center, and then they decide who is the kind of person that sees people in the common areas around where their institution or where their business is. Go ahead.
Is there any limitations on how close sex offender can live to a school or daycare, anything like that?
Not by virtue of Megan's laws. We're going to talk a little bit about sex offender parole and lifetime community supervision and civil commitment in a moment. But not Megan's laws. Megan's laws is just about understanding that they live in our community, they've paid the price, they've served their sentence, they've done their time, and they live in our community. And the belief is that because they are living in our communities, we ought to know that so that we can take steps to protect ourselves and our kids, because they're recidivistic, most of them, or many of them. So what is Megan's Laws about? It's about identifying where they are and telling people. It's not about acting like a parole board or probation board or telling them where they can't live. It's about saying, hey, he moved across from a daycare center, I'm going to tell that daycare center. So they can live near there, but we're going to tell them that the guy's there. Now, like I said, there are other ways to perhaps discourage them or compel them to stay away from certain areas, including daycare centers and the like. So Tier 2 is Little Falls, Caldwell, Long Branch, cops, and organizations. Also, you go on the internet, if. Not every Tier 2 is on the internet. If you are a juvenile, no internet. If you're a juvenile who's committed multiple offenses, you're on the internet. Juvenile with one offense, no internet. Multiple offender, internet. So again, out of the class of Tier 2s, if you drew a circle that represented all the Tier 2s, there's some lesser circle that goes on the internet. And it does not include kids. It does not include family and incest and household offenders. Unless they're multiple offenders. Multiple offenders go on the web. Incest and family offenders and household offenders, no web, and no children on the internet, unless they're multiple offenders. The next level of risk is Tier 3. Danger, danger, danger. High-risk sex offenders. These are the kinds of sex offenders that you don't need no stinking scale. You don't need no risk assessment instrument. You don't need a committee full of intellectual psychologists, psychiatrists, social workers, attorneys, and government employees to figure out that they're dangerous. These are the predators. These are the scary guys who lie in wait with a crowbar in the bushes. And when your car breaks down and you're changing your tire, they whack you over the head and they rape you. These are the guys who crawl through windows and rape people in their sleep, who use violence, the multiple offenders who beat their prey. Every one of these tier 3s are quite obvious and quite apparent. Thus, we notify the community, door to door. Well, that's a good question. And, Megan's Law, I often characterize Megan's Law as like this. It is kind of a societal safety net. It recognizes that the criminal justice system's flawed, and even the most vile, most despicable criminals get out sometimes and are at liberty or finish their sentences. We have to acknowledge and understand that among us are dangerous people. Not a lot. I'm never really scared no matter where I go in this country, not even in the cities. Some areas I, worry about a little, but even there, you're relatively safe, unless you're asking for it or you're out at 4 in the morning, in a known gang area. So there's dangerous people among us. But the likelihood of getting hurt is very low. But it's there. And we recognize that there are these dangerous people in a fallible system, in a system that cannot put everybody who's dangerous in a cage for the rest of their lives. So they're among us. So Megan's Law says we understand that, we acknowledge that, and we're going to empower ourselves and not sit by idly while they live among us. We're going to tell people that they're there. But you're right, the remedy, some would argue, ought to be lock them up longer and don't let them out. But and you kind of know this from this class, the criminal justice system and systems in general are not perfect. They're imperfect. And, prosecutions and jail time depends upon strength of case, persuasiveness of the victim, the jury accepting information and convicting. There are a lot of variables that go into how somebody gets from the crime stage to the jail cell. And juries compromise. Sometimes the evidence is weak. It is persuasive that they did that they did a terrible crime, but not beyond a reasonable doubt. So plea bargains are made. People go to jail for less than a life sentence. Otherwise, they'd go to jail for no time at all. We talked about prosecuting the prosecutable last week. I talked about prosecutors' discretion. I think you know how I feel about that you prosecute the cases that are strong enough to result in a conviction. To do otherwise would be to shortchange legitimate victims and to be wasting scarce resources on victims whose cases will not have an outcome that's helpful, and in fact might be deleterious to the child, to the victim, to the family. So we have plea bargains, and that is described and discussed in that February 21st lecture when I was sick. That's posted online. The plea bargain process benefits both parties. So what happens is people plea bargain, they get out of jail. Bad guys, bad people get out of jail. There's two ways to deal with them. One is to inform the public. That's what we're talking about now. The other I'll tell you about in a moment. So these tier 3s are high-risk sex offenders. But even then, we don't go around knocking on every door. We don't drop flyers from a transport plane. We go door to door in the neighborhood where the sex offender lives, works, or has a significant presence. And neighborhood differs depending upon where you live. You know, the neighborhood in Passaic or Patterson or Elizabeth or Newark or Camden or Rahway is smaller than, is less significant geographically, smaller in size than the neighborhood in West Orange, Wayne, Ridgewood. You know, in suburbia, your neighborhood's bigger. And in rural areas, it's even bigger. It was my case and my formulation on this issue that went to the appellate division and set the standard in New Jersey. And the way the detective and I figured this out when Megan's Law was first passed, because we had to come up with guidelines for my office to determine likely to encounter. Because remember, I said that's the Supreme Court's characterization of who in the neighborhood gets told. Those persons who are likely to encounter the sex offender. Well, I say that's the area where he has a significant presence, and that's the area in his neighborhood. But I took it even further. I said, likely to encounter. What would I do? The way I think to conceptualize this is, and I argue this to the appellate division, I said, and I don't smoke now, I smoked in my lifetime, and I said, if I wanted to go get a pack of cigarettes and a soda, how far would I have to go? And that loosely determined to me really what the neighborhood is, the zone of my community. It's not perfect, but it pretty much gave me the zone of my community depending upon how far I had to go to get a pack of cigarettes and a soda. Now you think about it for a minute. If you lived in Passaic or Elizabeth or Patterson or Newark, you might walk a block or two, maybe 3 blocks at most. Find yourself a bodega, buy a soda and a pack of smokes. Let's say 3 blocks. You go 3 blocks in each direction in a radius, that's kind of the neighborhood. You start going 4, 5, 6 city blocks. Look, that's still in where the guy lives, but it's, you know, that he ain't hanging with people 6 blocks away. His community is probably the 3 blocks that surround him. That's where he goes and gets a pack of smokes. That's where he goes down here to work out at the, you know, whatever, and do this or do that. Now, obviously, in this day and age, you got to get in your car and go places, but that's not what the Supreme Court's focused on. You know, the real answer to this is, like, everyone's likely to encounter a sex offender. We have bullet trains, 767 planes, and cars. The cheapest car in America goes 0 to 60 in 7 seconds now. So, you know, what is a neighborhood? Nevertheless, we're still operating under these old-fashioned constructs. So you got to stick to neighborhood. If you had to go buy a pack of cigarettes and a cold soda in Wayne, or, you know, I was born and spent early part of my life in Newark, and then I moved to Livingston. I lived in the city, and then I lived in classic suburbia in Livingston. I'd have to go about a half mile to get a soda and a pack of cigarettes at the 7-Eleven. So to me, that's kind of was about a half a mile, which is, you know, 2,500 feet. Now, if I lived in West Milford or Ringwood or Salem County, well, you got to get in your car and drive about 2 miles to get yourself a cigarette and a cold soda. So that's what we did. Those became the guidelines. When my case went to the appellate division, I made this argument. They asked me whether there was a rational basis, you know, for these distances, and I said, well, that's the way I conceptualized it. To me, that seemed to be reasonable. And they ruled we cannot argue with that. It's not unreasonable. And it became the de facto. By de facto, the rest of the states start using that. So it is, in New Jersey, 1,000 feet in the city, 1/2 mile in suburbia, and 2 miles in rural areas. And that's where we go door to door, banging on doors, talking to the people. 1,000 feet in the city, 1/2 mile in suburbia, and 2 miles in rural areas. All of that can be bigger or smaller depending upon the sex offender and the geography. For example, I told the appellate division, look, if the guy lives in Patterson and he's 10 feet from Route 80, I'm not going on the other side of Route 80 and knock on doors, because Route 80 cuts right through the neighborhood. It destroys the notion of neighborhood to his south. Or if there's a railroad station, if there's a natural boundary, a river, a highway, transportation, whatever it is, some kind of boundary, then you don't do the whole 1,000 feet or even the whole 1/2 mile. Because those kinds of things separate people and neighbors. So, again, my 1,000 feet, 1/2 mile, 2 miles is a starting point. Go ahead, Michaela.
You've heard of McNeil Island?
McNeil's Island? No.
Well, it's an island off, it's nearby Seattle. It's a small island.
Oh, okay.
Where they send tier 3 sex offenders after they served their prison time. They send them to that island. So I think they should do the island for all tier 3 sex offenders that are dangerous. I'm serious. Like, they can't be released back into society if they're going to reoffend again. I mean,
Well, I don't know exactly what that McNeil's Island is like, but I suspect that they must be getting treatment there or something. We don't live in a country where you take people and put them on an island, no matter what they've done.
let me see how long they're in.
It was a long term. And I think they do try to rehabilitate them, but the percentage that are actually rehabilitated are very small, like less than 5%.
Well, I'm going to get to that in a moment, so that must be part of the civil commitment process. So Tier 3, you notify the police, you notify schools, daycare centers, licensed community organizations, or registered community organizations, and the public in Little Falls, Caldwell, and Long Branch, if that's the case. And you go door to door, and you hand people flyers. You know, to me, you may get the sense I'm into computers and gadgets and modern technology. I mean, there can't be a more inefficient way to tell people stuff than that. But that's what we do. We're using technology from the Sheriff of Nottingham in the 15th century England. That's what they did in England in the medieval times. They go around knocking on doors. Ooh. There's a posse coming. There's a group of bad knights. Well, they don't trust the mail. The good news is this all may change in the next 4 or 5 years because there is a federal statute called the Adam Walsh Act that's going to change all the rules and allow for people to register. You know how I just subscribe for that discussion board? Well, you can subscribe for sex offender notifications. Get them text message to you. Go ahead. Well, that's a good point, and many people have made that counter argument, and that's one thing that might leave a gap in notification is seniors and others that don't use technology or use the internet. Well, I don't know. You see, what's going to happen here is these kind of points are well taken, but in a few years, the next generation of 60 and 70-year-olds are going to be internets. They're going to have access to the internet. Is going to be different generations, and they're becoming less and less places on the planet that are not wired. I mean, you can travel anywhere in the planet. And Carmen, did you have internet access in Dubai?
Yes.
Okay. Santiago just left the room. He was emailing me from Argentina his assignments right on time. Priscilla was popping me on my BlackBerry from, where were you, in Nigeria? She was in Nigeria. Bing, bing, hey, it's Priscilla. So
you're against the whole door-to-door?
no, I think there are better ways to do it. And I'll tell you what I am against. I'm against all these tiers. I think there ought to be tier 3, the worst sex offenders, and that's what we ought to focus on, and that's what we ought to notify the community about. And I got no problem going door to door on these really scary guys. But these tier 2s, there's a lot of guys in tier 2 that it's a colossal waste of time in my view. You send these flyers to the schools, they become desensitized, they get 10, 20 of them a year, and they really don't mean much anymore. They put them they pass them around, they show them around, they throw them in a file cabinet. I don't have a problem with collecting the data. The best part of Megan's laws is as an intelligence gathering process. Having their photos, having them confirm their address on a yearly basis, knowing where they are for law enforcement, greatest thing ever. Greatest thing. But sending out flyers to schools and daycare centers about moderately risky guys, you did the risk assessment, tier 2, tier 1, you know them when you see them. And these guys that are predatory and violent, they're the ones that we have to pay attention to. But that's not the law. The law is as I've described. Alp?
Is there any interstate agreement on sex offenders registration? Like if somebody moves to Rhode Island instead of New Jersey, if they are...
Well, there's not an interstate agreement that guides us on how to interact with other states. There is a statute called the Jacob Wetterling Crime Act. That was 1996, shortly after Megan's laws. That compelled all states to pass Megan's laws. So every state in the U.S. has to have a sex offender registration system. They vary. They're very different from state to state. Not very, but meaningfully different from state to state. They simply have to meet some basic requirements that the federal government outlined. The government sets a floor, and then you could take it higher than their requirements in any direction you want. But there's no interstate compact or agreement about how to interact with one another. And that's a problem. But some of these states are really draconian. It used to be, you ought to look this up. It's been a long time since I checked it out. Louisiana makes it's not funny. The sex offender's supposed to go door to door and notify the community. And he's required to have a bumper sticker on any car he might drive.
Why would the sex offender hide?
So that's the law of the great state of Louisiana.
Isn't that a dangerous thing? You might go down to the kid almost to throw on you a sex offender.
You think we care down here? You go out and knock on doors. That may not be the law anymore. I don't know. Billboards? Tier 3s on billboards? That's not true.
or living homes with kids? What determines that? Would that be like a tier 3? It's not supposed to live in the home with
No,
kids?
doesn't matter. Tier 3, Tier 2, Tier 1. You could dance in the park with children. Megan's Law does not tell people what they can and can't do. It is solely a system of registration and notification. However, there are two other statutes I want to talk about that do govern behavior. I'll talk about them in a second. So that's Megan's Laws. You've done a risk assessment, right? You submitted that to me. That's how we determine Tier 1, Tier 2, or Tier 3. We look at a number of factors that I described in the video that indicate whether someone's a low, medium, or high risk. That scale that you completed is then given to the registrant and his lawyer. And they have a right under the Doe decision, Doe versus Poritz, I mentioned earlier. They have a right under Doe versus Poritz to due process. Remember, in Ray GAULT gave children due process. Well, sex offenders have due process. Which means they can challenge your Tier 2 or Tier 3. So whatever you submitted to me, I would have to turn over to the defense lawyer and the registrant, the sex offender, and they could ask for a court hearing where I have to prove by clear and convincing evidence that the sex offender is a Tier 2 or Tier 3. And you can see by looking at that case how much information that you need to rely on to make those decisions. There were all kind of reports you had to read in order to fill out that form. That's what we do. And then we give it to the defense. He gets a free lawyer, and he gets to challenge it. And they come to court every other Friday, and they hold hearings to decide whether the risk assessment is accurate or not. If it is, the judge issues an order allowing Tier 2 or Tier 3 notification. If it isn't, the judge can modify the scale. One other thing, all Tier 3s get a free piece of jewelry from the Department of Corrections. This is relatively recent. You get a nice, looks great on the beach. You know those little anklet bracelets? Dangling. Only problem is this one's not 18 karat gold or platinum or sterling. It's the color of a manila folder. It's ugly and heavy. And it is connected to a satellite in the sky. So that little ankle bracelet beams itself thousands of miles in the sky, and that signal is beamed back to the World Wide Web so that your parole officer can log on at any time she wants and find out precisely where you are. And if you're not sleeping at 123 Main Street tonight, we'll know about it.
How long do they have those?
Forever. Or until they become a Tier 2. The only way to change your risk is to move. Because then you get evaluated again. Every time you move, you get evaluated again.
Move to another town or state, or it was just...
If you move from Building 1, Apartment 17 in CCP to Building 1, Apartment 3 in CCP, you got to register, and we got to do the risk assessment again.
Oh, wow. And the worst of taxpayers' money?
Yes. Well, not in that case it would be. But the idea is the risk assessment's based upon not only the person, but the geography of where they live, right? If they live near a daycare center, they might get a higher amount of points on that scale. There's certain categories that are geographically dependent. So if they move, you got to do the scale again. There's a lot of movement, but it's not because of this. It's just because a lot of them are very transient. They just move a lot. The two other ways that we protect the citizenry from recidivistic sex offenders are as follows. One is lifetime parole supervision. Many sex offenses now have lifetime parole supervision. It's called parole supervision for life. It passed when Megan's Laws passed. But this one only applies to people who committed their offense after October 31st, 94. Not people who were on probation or went to Avenel, because this is considered punitive. And it would be what we call ex post facto to apply it. Ex post facto says you can't pass a law today to punish something that was legal yesterday. So let's say parking in lot 10 of Montclair State is legal right now. Tomorrow, and you're parked there today. You go home, tomorrow morning you come to school, you find out they passed a new law this morning that says parking in lot 10 is a crime, 30 days in jail. Yesterday it wasn't a crime. Today it is. And they try to apply it what they call retroactively or backwards in time. Can't do that. That's called ex post facto. There is a constitutional provision that prevents the government from punishing yesterday's behavior today. But once they pass a law, if you commit an offense or do an act after the law is passed, then you are responsible. So with community supervision for life, that only applies to sex offenses that were committed after October 31st, 94.
How often does the supervision take place?
The question was, how often does the supervision take place? It all depends, but the standard conditions for parole supervision, were there standard conditions in that case file I gave you maybe? I don't remember.
Stand up for supervision.
Yeah, it might be referenced, but I don't see it here. In any event, lifetime supervision includes surprise polygraphs, prohibitions to be around children, to live near a daycare center, to have unsupervised contact with kids, to be on social networks, no Facebook, no Twitter, no MySpace, none of this stuff. There are laws that prevent people from doing those things. Your internet access is sharply curtailed. You can be compelled to go to drug counseling, Alcohol Anonymous, sex offender therapy, big part of supervision. So there's lots of conditions that apply to sex offenders that are different than average criminals, as you can tell from what I just expressed to you. You can apply to get off Megan's Law and supervision for life in 15 years. But that 15 years has to be crime-free and offense-free. So if you committed a criminal mischief by writing your tag on a stop sign, if you were involved in graffiti and you got charged with a criminal mischief, petty disorderly persons offense, the clock starts ticking again. 15 years, offense-free, you can apply to get off Megan's Law. After 15 years, you can also apply to get off supervision for life. If you have multiple convictions, you cannot get off either. Multiple sex offense convictions. Then a lifetime is a lifetime. You're on parole for life, and you're on Megan's for life. Till you die. So Megan's law is about identifying where sex offenders live and telling the community. Parole supervision for life is about supervising them, paying attention to what they're doing, and issuing restrictions about their behavior. And if you violate, you could be charged with an offense and go back to jail. Carmen?
What if somebody wants to leave the country and go on vacation with them?
If people want to leave the country or go on vacation, they need to have special permission. It can happen,
Okay.
but they need to have special permission.
What if they don't come back?
Well, then they're in violation of the law and they're charged.
Can you say,
Depends upon where they go, whether it's worth it, how important the case is. In the beginning, they wouldn't let sex offenders move out of state because none of the other states would take them under the interstate compact because they didn't have lifetime supervision. The implicit deal between states is, I got a guy who lives here, he wants to go to Indiana, he's on parole for a burglary. The Indiana guy wants to come to New Jersey, he's on parole for a domestic violence. It kind of balances out. People go back and forth, and you have an interstate compact where all the states accept parolees from each other. And there's this kind of movement to and fro. It kind of all balances out. All of a sudden, 1995, 1996, Indiana gets a case. Well, how long are you on parole for? 70 years? Till I die? What? We're not supervising you. It upset the balance. But now more and more states have supervision for life. That was a little bit more slowly adopted across the country. So there's more likelihood that you can move and get supervised in another state. But it has to be approved.
So you cannot move if the other state wants to supervise you for life?
Yes, that's correct. But it's easier to move. The other states are more likely to take you now because they have their own sex offenders who might be coming here or somewhere else. The third way that sex offenders are managed in a community is through the sexually violent predator laws. SVP. Sexually violent predator laws. Before, Michaela asked, how come we just don't keep these guys in jail? And I said, well, sometimes they get out because the case is weak, or the victim is afraid to testify, or they serve the maximum sentence. Well, there's a law that passed that says if a person suffers from a thought disturbance, if there's something that makes them a sexually violent predator, and they're likely to reoffend, they can be institutionalized, regardless of whether they have a mental illness. Throughout the centuries, you could civilly commit anybody. You or I could be civilly committed if two doctors conclude that we suffer a diagnosable mental illness and we're a danger to ourselves or others. But many of these sex offenders do not have a diagnosable mental illness. They're just sociopathic. They're just bad people who can't help themselves but want to rape. Well, those people can be civilly committed, not forever, but for a program of sex offender treatment. And they are on the campus of Rowway as well. In Kearney. The Sexually Violent Predator Unit is in Kearney, New Jersey. I wouldn't want to make a wrong turn and go knock on the door for directions there at 3 in the morning, though. So the law allows us now to file papers and ask the court to put dangerous sociopath rapists and child molesters in a secure mental health hospital until they are deemed fit to come back to society. And it doesn't matter whether a doctor can diagnose them with a mental illness. All that matters is that they have a screwy brain that makes them likely to rape again. They have a disturbance of thought. The national case was called Kansas versus Hendricks, Kansas. Kansas versus Hendricks was the Supreme Court case that allows sexually violent predators to be taken off the streets and put in a secure hospital. Here's the facts of the case. As the time neared for Leroy Hendricks' release from prison, having served for a long history of child sexual molestation, the state of Kansas sought his commitment under the Sexually Violent Predator Act. We have our own in New Jersey. The doctor testified that he suffered from pedophilia and is likely to molest again. And that he had a mental abnormality that caused him to be likely to engage in a predatory act of sexual violence. The question for the Supreme Court was the definition of mental abnormality too vague, too difficult to apply, that it violated due process? And the court said, no, it doesn't violate due process, because the law requires that they evaluate evidence of past violent behavior and present mental inclination. And people can get released once they become mentally stable. Excuse me. Thank you. Thank you. So the sexually violent predator statutes allowed the government to take people off the streets who are very dangerous and might molest again, simply based upon a mental abnormality, not based upon mental illness that's diagnosable by a doctor. Any questions about Megan's laws?
I was just reading something on this Catholic versus Hendricks, and it brought up the issue of double jeopardy in this case, because I guess they were first, because of the first conviction they got, this is like they've been convicted again by, not allowing them to be released, but it was still going to be released instead of confined.
Yes, Priscilla says one of the big issues in the Kansas versus Hendricks case was double jeopardy. And remember, double jeopardy means the government cannot try you for the same crime twice. Leroy Hendricks said, hey man, I paid my penalty. I might have molested lots of kids, but I went to jail, I did my time, and now it's time for me to get out. And they won't let me out. This is not what I expected. This is wrong. I served my time. You see, what happened to Leroy Hendricks was, he was all set to go home. And they go, oh, you're not going anywhere. Why? We're putting you in another jail. And he's like, that's double jeopardy. Well, jail was the wrong term. It's a secure hospital. You're probably better off still in jail. But anyway, so Hendricks argued that this violated the double jeopardy clause of the United States Constitution. That he served his time, and here you are punishing me again. I'll never get out. It's bizarre, surreal, Kafkaesque. But the Supreme Court said, no, you'll get out one day. Perhaps. It'd be interesting to see whatever happened to Leroy, and if he ever got out. I know a few prosecutors in Kansas. Maybe I'll shoot him an email. Any other questions about Megan's laws? Community supervision for life or parole supervision for life? Or the sexually violent predator laws? Yes?
Can you sue the police department if for some reason they don't contact you and one of these offenders
No.
harms your children?
No. There is a immunity clause, just like in the DIFUS laws, that holds the police and the government harmless if they screw up Megan's laws and don't do it right or fail to notify. No. Teddy?
Yeah, I'm still trying to figure out where in the process, which of the laws will determine, or to say do not have contact with children. Or sometimes we get the calls, this is a sex offender.
Community supervision for life.
So that becomes supervision for life.
Community supervision for life would have a typical provision that you don't have contact with children. But it depends upon the sex offender. If the sex offender raped an adult woman, let's say it's a campus rape, it's a frat house rape, sexual assault of an unconscious girl at a frat party. It's a crime. Guy gets prosecuted, goes to jail. They're not going to keep him away from preschoolers or children. It's not relevant to his offending behavior. So even the parole has to be tailored to the behavior of the sex offender. But if it's a child molester, then they ain't allowed to be around kids in an unsupervised way. That is a standard condition of parole for a child molester. I'll try to get a standard, show you next week a standard parole list that has all the conditions. Go ahead.
How do those rules work if the sex offender has children of his own? I mean, he has sex with his own children, his other children. How would visitations and stuff like that work?
Well, in that case, they have to be flexible and different, and I'm not sure. It all depends. There may be supervised visits. There may be no supervised visits. I'm not sure how that works, but I'll follow up on that, and I'll ask my colleagues who do this kind of work.
But then would they, I know that the parole process involves approving them to certain locations. Would they now be approved to be paroled to that particular home, like back to their home where they have children, like stuff like that? I guess that would determine if they're approved to go to that kind of place.
Yes, Priscilla says that parole only allows persons to go to approved locations. And wherever they go has to be approved by parole. So whether they can live with their own children, it has to be approved by parole. Where they can live, whether they can live in an area where there's a park, it has to be approved by parole.
We've gotten situations where, they come out, they find an apartment, they live by themselves, they then they get a girlfriend, get another kid from that girlfriend. Now the argument is, are we going to go there and say you cannot live here, that you can divorce? We just had a case like that about 3 weeks ago. Where, he has other kids, he wasn't paroled to those homes, he got an apartment, got a new girlfriend, now they have a child today, an infant. And he's like, well, do I leave my apartment? But the good thing was, then they found out he wasn't, registered. So that's the violation.
The good thing was we wound up locking him up.
Yeah, so he didn't register, so they came and picked him up. But, he might come out, who knows?
Well, I'm going to make myself note and check with parole. One question was own kids or guy who moves in with girl with kids. I'm going to find out what their policy is on these kind of things. They tend to be very strict. Very strict. But I'll find out. What else? Anything else? What's that? Becky Island? What's the name of the island again?
We can send all of them. See what they take one from the other.
You know what they say. First they came for the sex offenders. We may all wind up on Becky's Island or whatever the heck it's called. Any other questions? Listen, the examination's going to be through Becky's Island. From day one till this day today. Today's lecture will be posted tonight online. All the other ones are there. You don't have to listen to them. They're just there in case you need them. But all the materials are there. It's going to be through today's lecture. It's going to be, I think it's 25 questions, approximately. They are a combination of multiple choice, fill in the blank, true, false. You'll be taking them at your computer screen right here. You'll log on to Blackboard, and you'll click on the exam, and it'll appear, and then you'll just go down the line and just click on the right answer. If you have any questions, post it to the discussion board, and we'll try to answer them. Any other questions? All right, we're off next week. Question?
Yes, learning project 3 is not going to be on the agenda, right?
Learning Project 3 is the one I just talked about, Crandall? No. No Learning Project 3. So you have 2 weeks between now and the exam. So review your readings, post to not to the cyber cafe this time, although you can, I don't really care, but you want to post to the exam discussion board so that other people can see it. And, I'll respond. So I'll see you 2 weeks from today.